line-by-line scrutiny of the Crime and Policing Bill. According to the programme order agreed at the start of the committee stage, the PBC must conclude today at 5 p.m.
On a point of order.
Point of order, Dame Diana Johnson.
Thank you very much, Dr. Khan and Razan Khan. Sorry, I've got your name wrong already. That's not a good start to today.
Don't worry, you went first.
Well, thank you for allowing the point of order. I just wanted to clarify remarks that I made during the previous day of committee regarding officer numbers in the Metropolitan Police. This was in response to a point raised by the Honourable Member for Sutton and Sheen. I stated that the government anticipated that under the MOPAC budget for 25-26, there will be a reduction of around 1,000 police officers and PCSOs within the Metropolitan Police. Can I say there has been some confusion over the number that's anticipated in the reduction of police, PCSOs and staff at the Met, which has been very unhelpful really in getting a clear picture. The final MOPAC budget report actually states that the Met Police is expecting a reduction of 1,419 full-time equivalent officers, PCSOs, including staff as well, as opposed to the 1,700 figure that has been previously reported. And as I said in my remarks at the end of last week, I am obviously concerned about reductions, and this government has done everything it can to minimise the number of officers and staff and PCSOs who will be losing their roles. And I hope that clarification is helpful to the committee. Thank you.
Before we begin the line-by-line scrutiny, I have a few preliminary reminders for the committee. Please switch electronic devices to silent. No food or drinks are permitted during sittings of this committee except for the water provided. Hansard colleagues would be grateful if members could email their speaking notes to hansardnotes@parliament.uk or alternatively pass on their written speaking notes to the Hansard colleague in the room. Members are reminded to bob and catch my eye if they wish to speak in any debate. We now come to new clause 42, which has already been debated. Matt Vickers to move formally.
42, do we say?
42.
Beg to move.
Report on the organisations responsible for implementing and enforcing youth diversion orders.
The question is that new clause 42 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
That's not
Yeah.
Yeah. Can we just do that for all?
Let me know when you're ready to proceed with the division. Yep. Lock the doors.
Alex Farris-Curtis?
No.
Matt Bishop?
No.
David Burton-Sampson?
No.
Harriet Cross?
Aye.
Alex Davis-Jones?
No.
Dame Diana Johnson?
No.
Louise Jones?
No.
Keir Mabur?
No.
Jess Phillips?
No.
Joe Platt?
No.
Joe Robertson?
Aye.
David Taylor?
No.
Luke Taylor?
Abstain.
Matt Vickers?
Aye.
The ayes were 3, the noes were 10, so the noes have it, the noes have it. Unlock. We now come to new clause 43, which has already been debated. Matt Vickers to move formally.
Beg to move.
Travel abroad to support a prescribed organisation.
The question is that new clause 43 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
Division in room 11.
Are you ready? Let me know when you're ready. Okay, lock the doors.
Alex Farris-Curtis?
No.
Matt Bishop?
No.
David Burton-Sampson?
No.
Harriet Cross?
Aye.
Alex Davis-Jones?
No.
Dame Diana Johnson?
No.
Louise Jones?
No.
Keir Mabur?
No.
Jess Phillips?
No.
Joe Platt?
No.
Jack Rankin,
Aye.
Joe Robertson,
Aye.
David Taylor,
No.
Luke Taylor,
Abstain.
Matt Vickers,
Aye.
The ayes were 4, the noes were 10, so the noes have it, the noes have it. Unlock. We now come to new clause 42, which has already been debated. Matt Vickers to move formally.
Beg to move.
individual preparation for mass casualty attack.
The question is that new clause 44 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
Division 11.
Ready?
Yep.
Yep, okay.
Alex Barris Curtis,
No.
Matt Bishop,
No.
David Burton Sampson,
No.
Harriet Cross,
Aye.
Alex Davis Jones,
No.
Dame Dan Johnson,
No.
Louise Jones,
No.
Keir Mabber,
No.
Jess Phillips,
No.
Joe Platt,
No.
Jack Rankin,
Aye.
Joe Robertson,
Aye.
Dr Lawrence Sullivan,
No.
David Taylor,
No.
Luke Taylor,
Abstain.
Matt Vickers.
Aye.
The ayes were 4, the noes were 11, so the noes have it, the noes have it. Unlock. We now come to new clause 45, which is tabled by a member who is not on this committee. Does any member wish to move new clause 45? We now come to new clause 46, which was tabled by a member who is not on this committee. Does any member wish to move new clause 46?
Yes.
Matt Vickers.
Thank you. It is a pleasure to serve under your chairmanship. I know this amendment was put forward by the Honourable Member for Reigate in an effort to raise a subject affecting many of her residents. She said that dangerous delivery drivers have become an increasingly common sight on the roads in Reigate, Banstead and Redhill. She's spoken with constituents who report near misses, actual collisions and a growing sense that people and property is increasingly put at risk from these individuals who simply don't have the skills to operate their vehicles safely. She believes her amendment will both address this problem and at the same time protect the rights of regular moped users. In a world where there are an increasing number of home delivery transactions being undertaken, there are more and more delivery drivers on our streets. Many of these are not properly qualified to drive and are on our streets in increasing numbers, potentially working long shifts, finding addresses in areas that are alien to them. The fact they're doing so using a licence that exists to allow people to learn to drive poses real challenges to road safety. The clause seeks to amend Section 59 of the Police Reform Act 2002, which grants police powers to seize vehicles being used in a manner that causes alarm, distress or annoyance. It adds a new subsection 3A, which would deem mopeds being used for commercial purposes by riders with only provisional licences as likely to fall into that category, effectively lowering the threshold for police action in such cases. The use of mopeds for delivery services, e.g. food and parcels, has expanded rapidly. However, a concerning number of these riders continue to operate on provisional licences, often without any training or supervision. This puts both the riders and the public at risk. By allowing the police to treat such behaviour as likely to cause alarm or distress, this clause ensures faster and more decisive action to remove unsafe vehicles from our roads. The adoption of new clause 46 as put forward by the Honourable Member for Reigate will allow police to actively deal with individuals on mopeds abusing this lack of legislation. If not supportive of this clause, I'd welcome the Minister's views on how this issue can be tackled.
Seizure of vehicles by police, mopeds used for commercial purposes.
The question is that new clause 46 be read a second time. Dame Dan Johnson.
Thank you very much, Dr Alan Khan, and I am very grateful to the Honourable Member for setting out the case for this new clause on behalf of his Honourable friend, the Member for Reigate. And as he explained, new clause 46 raises the important issue of mopeds being used for commercial purposes while the rider has a provisional licence. And I can assure members of the committee that any kind of antisocial behaviour is unacceptable, which is why the government is undertaking an ambitious programme of work to tackle it. And the antisocial use of vehicles like e-scooters and off-road bikes causes havoc in local communities, something we all know from our own constituency postbag. We are making it easier for the police to seize these vehicles from offenders and dispose of them. And as we've already debated in Clause 8 of the bill, this strengthens the law so that vehicles being used in an antisocial way can be seized immediately by police when they are used to commit antisocial behaviour without the need to first provide a warning. Furthermore, the Department for Transport, together with the Driver and Vehicle Standards Agency, is considering plans to review existing requirements for motorcycle training, testing and licensing, taking account of recent proposals suggested by the motorcycle industry. And currently, as we've heard, it is legal for moped riders with provisional licences to work as delivery drivers. This new clause would therefore create an ambiguity in the law which could result in confusion for the moped riders, employers and police, because it is legal to drive on a provisional licence for these purposes but still have your moped seized. Secondly, there is no clear definition of what a commercial activity is. This could cover a range of scenarios. It could extend to food and grocery delivery riders, couriers, parking enforcement officers, medical laboratory technicians, blood bank workers, etc. So this could result in these sectors operating with diminished capability. Now, the proposals may also result in the unintended consequence of a rise in the use of modified electrically assisted pedal cycles that do not comply with current EAPC regulations for use on public roads, or the illegal use of off-road bikes on public roads for the same commercial purposes. And the Shadow Minister asked a question about, well, what more could we do around this? And I just wanted to highlight Transport for London, who have launched a road safety charter for meal and grocery delivery companies in September 23 to identify ways to reduce death and serious injury amongst riders and to raise road safety standards. And this charter was developed in collaboration with the then 5 largest meal and grocery delivery companies and consists of 10 road safety principles that aim to keep food delivery, motorcycle couriers and other road users safe. TfL is currently evaluating the impact of the Charter's implementation over the last 18 months and will share its findings with government in due course. So on that basis, I would ask that the opposition withdraw new clause 46.
Matt Vickers.
Content to withdraw.
Is everyone content for the new clause to be withdrawn?
Agreed.
New clause by leave withdrawn. We now come to new clause 47, which has already been debated. Matt Vickers to move formally.
Beg to move.
National statutory inquiry into grooming gangs.
The question is that new clause 47 be read a second time. As many as are of that opinion say aye.
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 Of the contrary, no.
No.
Division.
Division.
Ready? Okay. Lock the doors.
Mr. Alex Barros-Curtis?
No.
Matt Bishop?
No.
David Burton-Sampson?
No.
Harriet Cross?
Aye.
Alex Davis-Jones?
No.
Dame Dan Johnson?
No.
Louise Jones?
No.
Keir Mather?
No.
Jess Phillips? Joe Platt?
No.
Jack Rankin?
Aye.
Joe Robertson?
Aye.
Dr. Lauren Sullivan?
No.
David Taylor?
No.
Luke Taylor?
Abstain.
Matt Vickers?
Aye.
The ayes were 4, the noes were 10, so the noes have it, the noes have it. Unlock. We now come to new clause 48, which has already been debated. Matt Vickers to move formally.
Beg to move.
Annual statement on ethnicity of members of grooming gangs.
The question is that new clause 48 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
Division 11.
Lock the doors.
Alex Barrett-Curtis?
No.
Matt Bishop?
No.
David Burton-Sampson?
No.
Harriet Cross?
Aye.
Alex Davis-Jones?
No.
Dame Diana Johnson?
No.
Louise Jones?
No.
Keir Mather?
No.
Joe Platt?
No.
Jack Rankin?
Aye.
Joe Robertson?
Aye.
Dr. Lauren Sullivan?
No.
David Taylor?
No.
Luke Taylor?
Abstain.
Matt Vickers?
Aye.
The ayes were 4, the noes were 10, so the noes have it, the noes have it. Unlock. We now come to new clause 49, which has already been debated. Matt Vickers to move formally.
Beg to move.
Publication of sex offenders' ethnicity data.
The question is that new clause 49 be read a second time. As many as are of that opinion say aye.
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 Of the contrary, no.
No.
Division. Lock the doors.
Alex Barrett-Curtis?
No.
Matt Bishop?
No.
David Burton-Sampson?
No.
Harriet Cross?
Aye.
Alex Davis-Jones?
No.
Dame Diana Johnson?
No.
Louise Jones?
No.
Keir Mather?
No.
Joe Platt?
No.
Jack Rankin?
Aye.
Joe Robertson?
Aye.
Dr. Lauren Sullivan?
No.
David Taylor?
No.
Luke Taylor?
Abstain.
Matt Vickers?
Aye.
The ayes were 4, the noes were 10, so the noes have it, the noes have it. Unlock. We now come to new clause 50. I call Matt Vickers.
Thank you. New clause 50 would amend the Children's Act 1989 to introduce a new provision, section 2A, which suspends parental responsibility for any individual convicted of serious sexual offences involving or relating to children. It's not in a child's best interest for a person who's committed a serious sexual offence against a child to retain any legal rights over them, whether that child was the direct victim or not. This clause puts child safety above all else by ensuring there is no ambiguity about the offender's legal standing as a parent. While the courts do have the power to strip parental responsibility when it's in the best interests of a child, currently it requires families and former partners of perpetrators to instigate and fund proceedings to secure these orders to protect their children. Costs for these types of proceedings can run into tens of thousands of pounds. However, under the new rule, the automatic suspension would make proceedings more simple. This clause sends a powerful message. Those who commit serious sexual offences against children forfeit the rights of parenthood. Parenthood comes with responsibilities, chief among them the duty to protect. Breaching that duty in the most serious and damaging way should have equally serious consequences under the law. There's a wide public and cross-party support for measures that prioritise the protection of children over the rights of offenders. This clause ensures the law reflects both moral clarity and practical necessity, putting children first and ensuring legal rights are not abused by convicted predators. This clause introduces a long overdue legal safeguard for vulnerable children. It ensures that no individual convicted of a serious child sex offence can continue to exercise legal power as a parent whilst in prison, unless and until a court independently decides it is safe and appropriate to do so. It strengthens the child protection framework and puts survivors' welfare and dignity at the centre of family law.
Minister.
Thank you, Dr. Alan Carn.
Sorry.
Oh.
Removal of parental responsibility for individuals convicted of sexual offences against children.
Minister Alex Davis-Jones.
Thank you, Dr. Alan Carn. New clause Amendment 50, tabled by the Honourable Member for Stockton West, seeks the automatic removal of parental responsibility where a parent has been convicted of a serious sexual offence against a child. To begin with, I wish to be clear that child sexual abuse is an abhorrent crime that leaves a lasting impact on victims and their families, and those affected have my deepest sympathies. The Honourable Member's motivation in bringing this amendment is laudable. Protecting children and vulnerable adults is a top priority for this government. However, there are several compelling reasons why we cannot support this specific amendment. Firstly, the amendment does not define which offences would be in scope. Without this clear definition, what is being considered serious is left open to interpretation. That could lead to potential disparity in the protections offered to child victims and their families. Similarly, it is not clear what is meant by a crime involving or relating to a child or children. Again, there are a range of interpretations of this wording, meaning that there is yet more chance of this amendment being inconsistently applied and offering uneven protections for children. Furthermore, the measure appears to confuse several concepts in the existing law around parental responsibility. The amendment uses phrases such as removal, termination and suspension interchangeably. In practice, these are distinct differences between restricting or removing a person's parental responsibility and suspending it. This would place the provision in opposition to the wider law on parental responsibility, which has its roots both in legislation and extensive case law. The amendment leaves precisely which of these approaches should be taken open to interpretation in each individual case, which reinforces the potential for variable application. In short, this amendment contains some clear, very clear actual problems that undermine its good intentions. However, I do want to reassure the committee that we do intend to legislate to protect the children of child sex offenders. Members may be aware that in the King's Speech we made a commitment to protect the public from sex offenders, including by restricting the parental responsibility of child sex offenders. I am extremely pleased to confirm that the Government has included a measure to this effect in the Victims and Courts Bill that was introduced to the House last Wednesday. This measure will provide the automatic restriction of the exercise of parental responsibility of offenders sentenced to 4 or more years imprisonment for serious child sexual abuse offences against a child for which they hold parental responsibility. The exercise of the offender's parental responsibility will be restricted to the point where they cannot take any meaningful action in relation to any of their children. This will mean that our measure, which is driven by the same motivations as the honourable members, will provide workable protections for the children of those convicted of serious child sexual offences and will be fairly applied in all circumstances. The honourable members' amendment has a worthy aim. All of us have a huge amount of sympathy for the children who are in these awful situations, and we all want to do everything that we can to protect them from harm, and that harm that could be caused by parents, who are the people who should keep them safe, but are the perpetrators of serious child sexual abuse offences. However, given the problems with this specific amendment that I have already mentioned, and the measures that the Government has included in the Victims and Courts Bill, I urge him to withdraw this amendment.
Wish to move to division?
New clause 50 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division.
Division in number 11.
Lock the doors.
Alex Barras-Curtis.
No.
Matt Bishop.
No.
David Burton-Sampson.
No.
Harry Cross.
Aye.
Alex Davis-Jones.
No.
Dame Dana Johnson.
No.
Louise Jones.
No.
Keir Mather.
No.
Jess Phillips. Joe Plaid. Jack Rankin.
Aye.
Joe Robertson.
Aye.
Dr. Lauren Sullivan.
No.
David Taylor.
No.
Luke Taylor.
Aye.
Matt Vickers.
Aye.
The ayes were 5, the noes were 10, so the noes have it, the noes have it. Unlock. We now come to new clause 51, which has already been debated. Matt Vickers to move formally.
Beg to move.
Amendment of possession of extreme pornographic images.
The question is that new clause 51 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
Division in 11.
Ready? Everyone ready? Lock the doors.
Mr. Alex Barras-Curtis.
No.
Matt Bishop.
No.
David Burton-Sampson.
No.
Harry Cross.
Aye.
Alex Davis-Jones.
No.
Dame Dana Johnson.
No.
Louise Jones.
No.
Keir Mather.
No.
Jess Phillips.
No.
Jack Rankin?
Aye.
Joe Robertson?
Aye.
Dr. Lauren Sullivan?
No.
David Taylor?
No.
Luke Taylor? Matt Vickers?
Aye.
The ayes were 4, the noes were 10, so the noes have it, the noes have it. Unlock. We now come to new clause 52. I call Matt Vickers.
Thank you. This new clause seeks to amend the Sentencing Act 2020 to ensure that the starting point for sentencing anyone convicted of the murder of a child is a whole life order. Specifically, it proposes amending Schedule 21, paragraph 2.2 to insert the murder of a child as a standalone aggravating factor, warranting the highest penalty available under the law. The murder of a child is one of the most heinous and incomprehensible crimes in our society. It represents a total breach of the duty of care and protection that adults owe to children, the most vulnerable members of our communities. Unlike many other forms of homicide, the murder of a child is rarely spontaneous and often involves an abuse of trust, authority or access. These are crimes that permanently scar the moral fabric of society and must be treated with the utmost severity in our justice system. Under the current law, a whole life order for child murder is only applied in cases involving additional aggravating factors, such as abduction, sexual abuse or premeditated sadism. This creates an unjust distinction that can result in disparities in sentences. A child's life is not made more or less valuable by the specific nature of the crime. The act of taking a child's life should, in itself, warrant the strongest possible sentence. This clause would eliminate ambiguity and bring clarity and consistency to sentencing practice, ensuring that the most severe punishment is applied to the most serious offence. By making the starting point for child murder a whole life order, Parliament would send a powerful and an ambiguous message that the deliberate killing of a child will never be met with any leniency. This not only strengthens public confidence in the justice system, but also serves as a deterrent to those who might commit such unforgivable acts. It reinforces the principle that the protection of children is paramount and that their murder is an attack on the very core of civilised society. This new clause recognises the unique horror of child murder and ensures that our sentencing laws reflect that reality. By adopting this measure, we show victims' families that their suffering is acknowledged, and we uphold the principle that the life of every child must be fiercely protected in both law and in practice.
Child murder sentencing guidelines.
The question is that new clause 52 be read a second time. Minister.
Thank you, Chair. New clause amendment 52, tabled by the Honourable Member for Stockton West, seeks to make the starting punishment for child murder a whole life order. I want to first thank the Honourable Member for his commitment to tackling crimes involving children and reiterate the offer made by my Honourable friend, the Safeguarding Minister, in the last session, that if the Shadow Minister seriously wishes to address these crimes and all of the other crimes that we have debated throughout the committee session, then the offer stands that we stand willing to work with any member across the House to make that a reality. But as of yet, no offer has come forward. I do share the desire, as many do, to ensure that those responsible for these terrible crimes are punished properly. The murder of those most vulnerable in our society causes extreme grief and devastation for loved ones that are left behind, and those affected have my deepest sympathies. It may be helpful, Chair, if I first set out in what circumstances the murder of a child would currently receive a whole life order. Everyone convicted of the murder of a child will receive a life sentence. This means that they will only be released after serving their minimum term if the parole board is satisfied that their detention is no longer necessary for the protection of the public. Even if released, and I say if, the offender will remain on licence for the rest of their life, subject to recall to prison if they breach the conditions of their licence. When a life sentence is imposed, the court must determine the minimum period to be served in custody for the purposes of punishment and deterrence. When sentencing adult offenders, the starting points are 15, 25 or 30 years, or a whole life order. Judges must then consider relevant aggravating and mitigating factors and adjust the minimum term accordingly. Whole life orders are for the most severe form of punishment that the courts can impose. These sentences have no tariffs and no possibility of parole board release. As such, they are reserved for the most heinous cases of murder. There are currently 69 offenders serving whole life orders in our prisons as of the 31st of December 2024. There are certain instances of child murder that are regarded as so heinous that they are normally subject to a whole life order starting point. Currently, a whole life order will normally be the appropriate starting point for the murder of a child if involving A, the abduction of a child, B, sexual or sadistic motivation, or C, a substantial degree of premeditation or planning. Additionally, some instances of child murder may also fall within other circumstances where a whole life order is normally the appropriate starting point. These additional circumstances apply to murders involving victims of any age. For example, a murder done for the purpose of advancing a political, religious, racial or ideological cause, or a murder committed by someone already convicted of murder. The court may also impose a whole life order for murders where it considers the seriousness of the offence is exceptionally high, even if it does not fall within one of the categories of the case specified as normally warranting a whole life order starting point. With regards to the Honourable Member's amendment, there are several reasons why we cannot support it. Crucially, it is important to recognise that cases involving the murder of a child can be incredibly complex, and it is therefore right that we do not introduce legislation that treats them all the same. Given their severity, whole life orders must be reserved for the most serious cases, and it is right that in other cases judges retain broader discretion to impose the appropriate minimum term in accordance with the statutory framework. However, the Government does recognise that there are serious concerns regarding homicide law and sentencing which do need addressing. The Lord Chancellor recently announced a Law Commission review of homicide law and sentencing. This review will consider the law relating to homicide offences, including full and partial defences to those offences, and the existing sentencing framework for murder as set out in Schedule 21 of the Sentencing Act 2020. Any changes to Schedule 21, including to whole life orders, will therefore be considered in the context of the Law Commission's review. The Law Commission planned to begin their work on this review earlier this year, and we understand that it will publish a timeline of that work shortly. It would not be right to anticipate the recommendations of the Commission by introducing legislation on murder sentencing prior to the publication of its review. Instead, the findings of the Law Commission should be considered independent and in their totality. I would like to finish again by thanking the Honourable Member for his commitment to punishing offenders that commit crimes against children. However, as I hope I have made clear, crimes against children are complex and need all due consideration in sentencing by the independent judiciary. I therefore urge the Honourable Member to withdraw his amendment.
Chairman, Mr. Matt
Wish to move.
New clause 52 proposed, as on the amendment paper. The question is that this clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division.
Division number 11.
Lock the doors.
Mr. Alex Barras-Curtis?
No.
Matt Bishop?
No.
David Burton-Sampson?
No.
Harriet Cross?
Aye.
Alex Davis-Jones?
No.
Dame Dana Johnson?
No.
Louise Jones?
No.
Keir Mather?
No.
Jess Phillips?
Aye.
Jack Rankin?
Aye.
Joe Robertson?
Aye.
Dr. Lauren Sullivan?
No.
David Taylor?
No.
Luke Taylor?
Yes.
Matt Vickers?
Aye.
The ayes were 5, the noes were 10. So the noes have it, the noes have it. Unlock. We now come to new clause 53, which has already been debated. This new clause was tabled by a member who is not on this committee. Does a member of the committee wish to put this new clause to a division? We now come to new clause 54. I call Matt Vickers.
Thank you. This clause introduces a new aggravating factor into sentencing decisions for child sexual abuse offences under the Sentencing Act 2020. It establishes that where an individual has financially profited directly or indirectly from the exploitation or abuse of a child, this financial gain must be treated as a serious aggravating factor. It also requires the court to state this publicly when passing sentence. The sexual exploitation of children is among the most reprehensible offences in our society. a betrayal of innocence, safety and human dignity. When such abuse is monetised, the moral gravity of the offence is even more severe. Turning child abuse into a source of financial gain elevates the exploitation to an industrial scale. It transforms the victim into a commodity and incentivises further harm. This clause ensures that courts recognise and respond firmly to this added layer of depravity. Unfortunately, technological advancements and global criminal networks have enabled an alarming increase in the commercial exploitation of children. Offenders now profit through various means, including the sale of abuse material online, live streaming of abuse for paying viewers, or trafficking children for sexual purposes. In some cases, even possession or circulation of indecent images may serve broader financial interests. This clause ensures the law keeps pace with the evolving methods of abuse and exploitation. Sentencing must reflect not just the harm caused to the victim, but also the motives of the offender. Financial gain reflects cold, calculated and deliberate exploitation. It suggests repeat offending, involvement in networks and disregard for long-term consequences. By making financial profit a statutory aggravating factor, this clause helps judges deliver sentences that match the exceptional seriousness of these crimes. This clause aligns sentencing practice with the lived reality of modern child sexual exploitation. It makes clear that child abuse must never be a source of profit, and that those who attempt to benefit from such vile acts will face significantly enhanced punishments. In doing so, it strengthens justice, deters future harm, and places victim suffering at the heart of the legal response.
Financial gain from child sexual exploitation and abuse.
The question is that new clause 54 be read a second time. Minister.
Thank you, Chair. I thank the Honourable Member for Stockton West for his amendment. I understand that the purpose of this amendment is to create a statutory aggravating factor when sentencing for any individual who has financially benefited from the creation, distribution, possession or publication of any specified child sexual abuse offence. Whilst I agree wholeheartedly with the spirit of the proposed amendment, I must inform the Honourable Member that the Sentencing Council guidelines already provide the courts to lengthen sentences where an offender has financially benefited from a sexual offence committed against a child. Sentencing guidelines are developed by the Independent Sentencing Council for England and Wales, and all sentencing courts must follow any sentencing guidelines which are relevant to the offender's case unless it is in the interests of justice to not do so. Overarching sentencing guidelines must include commission of the offence for financial gain and high level of profit from the offence as aggravating factors which courts can apply to any relevant offence. Sentencing guidelines for sexual offences also include commercial exploitation and or motivation as a high culpability factor, increasing the starting point that the courts apply when deciding upon a sentence. This amendment risks introducing confusion in applying the existing provisions. Furthermore, by specifying the offences to which the factor applies, it could actually inadvertently narrow the range of cases where financial gain is considered an aggravating factor. It is for those reasons that I therefore urge the Honourable Member to withdraw his amendment.
Minister Matt Vickers wish to move. New clause 54 proposed, as in the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
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 To the contrary, no.
No.
Division.
Division from 11.
Lock the doors.
Mr. Alex Farris-Curtis? No. Matt Bishop?
No.
David Burton-Sampson?
No.
Harriet Cross?
Aye.
Alex Davis-Jones?
No.
Dame Diana Johnson?
No.
Louise Jones?
No.
Keir Mather?
No.
Jack Rankin?
Aye.
Joe Robertson?
Aye.
Dr. Lawrence Sullivan?
No.
David Taylor?
No.
Luke Taylor?
Aye.
Matt Vickers?
Aye.
The ayes were 5, the noes were 9. So the noes have it, the noes have it. Unlock. We now come to new clause 55, which has already been debated. Matt Vickers to move formally.
Beg to move.
The question is that new... Sorry.
Annual Statement on Employment Status of Sexual Offenders.
The question is that new clause 55 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
Division 11.
Lock the doors.
Mr. Alex Barras-Curtis.
No.
Matt Bishop.
No.
David Burton-Sampson.
No.
Harriet Cross.
Aye.
Alex Davis-Jones.
No.
Dame Diana Johnson.
No.
Louise Jones.
No.
Keir Mather.
No.
Jess Phillips not here. Joe Platt. Jack Rankin.
Aye.
Joe Robertson.
Aye.
Dr. Lauren Sullivan.
No.
David Taylor.
No.
Luke Taylor.
Abstain.
Matt Vickers.
Aye.
The ayes were 4, the noes were 9. So the noes have it, the noes have it. Unlock. We now come to new clause 57. I call Matt Vickers.
The opposition believes that the current Sexual Offences Act 2003 falls short in not addressing the issue of sexual relationships between first cousins. New clause 57 sets out to abolish this loophole by explicitly prohibiting sexual relationships between first cousins, bringing these relations in line with prohibitions surrounding other familial relationships. New evidence published by the BBC in February 2025, drawn from new data from the Born in Bradford study conducted by researchers at Bradford University, has highlighted the key health and social issues caused by consanguineous marriage amongst first cousins, which new clause 57 seeks to address. In regard to health, a child of first cousins is twice as likely to inherit a recessive disorder. Examples of such disorders include cystic fibrosis and sickle cell disease. Indeed, in the private members' bill introduced by the Right Honourable Member for Basildon and Billericay, data was presented showing the higher risk of birth defects, increased infant mortality rates, and more heart, brain and kidney problems due to recessive disorders born to cousin parents. The medical evidence shows that health conditions and genetic disorders are compounded through cousin marriage, particularly when the practice persists through generations with a family or wider community. If we consider that marriages may amount to potentially thousands each year, some may argue that this is a minor issue, but if it involves an act we regard as deeply damaging to the potential health of a person's child, then it cannot be ignored. To do so would be deeply irresponsible.
Prohibition on sexual relationships between first cousins.
The question is that new clause 57 be read a second time. Minister.
Thank you, Chair. And again, I thank the Honourable Member for this amendment, which would extend existing offences relating to sexual activity between certain family members to include first cousins. Now, the Sexual Offences Act 2003 currently makes it a criminal offence for a person aged 16 or over to sexually penetrate an adult family member where they are related as a parent, grandparent, child, grandchild, brother, sister, half-brother, half-sister, uncle, aunt, nephew or niece. The rationale for this offence in relation to the issue of sexual relations between family members generally is the fundamental breach of trust involved in particular family members engaging in sexual activity with other family members. It is also important to acknowledge that criminal offences help ensure that patterns of abuse established in childhood are not allowed to continue into adulthood. I must say, as the Shadow Minister has already stated, that if the intention of this amendment is to prevent marriage between first cousins, then this bill is the wrong vehicle. It is the Marriage Act 1949 that deals with prohibited degrees of relationship for marriage. It is therefore the case that under this amendment, while sexual penetration between first cousins would become a criminal offence in certain circumstances, first cousins would still be able to legally marry. Marriage will always be one of our most important institutions, and we must and are considering any recommendations to change weddings law carefully, including in relation to cousin marriage. I acknowledge that the proposed amendment does not seek to criminalise continued sexual relations between first cousins where the sexual relationship started before this bill has passed. However, the practical reality would be that many first cousins would be permitted to continue having sex, whilst for others this would now become criminal behaviour. The amendment also seeks to make it a specific criminal offence for a person to sexually touch a child who is their first cousin, to incite a child who is their first cousin to engage in sexual activity where the child is under 18 and the perpetrator does not reasonably believe that they are aged 18 or over. Now, I want to state to the committee that regardless of this amendment, it is already an offence for anyone of any age to engage in sexual activity with children under the age of 16, even if that child purports to give their consent. These are serious sexual offences and treated as such across the criminal justice system. We consider the existing protections for children under 16 to be sufficient. Therefore, for the reasons that I have set out, I ask that the Honourable Member withdraw his amendment.
Thank you.
New clause 57 proposed is on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division.
Division in room 11.
Lock the doors.
Mr Alex Harris Curtis.
No.
Matt Bishop.
No.
David Burton Sampson.
No.
Harriet Cross.
Aye.
Alex Davis Jones.
No.
Dame Diane Johnson.
No.
Louise Jones.
No.
Ian Mavor.
No.
Joe Platt.
No.
Jack Rankin. Dr Lauren Sullivan.
No.
David Taylor.
No.
Luke Taylor.
Abstain.
Matt Vickers.
Aye.
The ayes were 3, the noes were 10, so the noes have it, the noes have it. Unlock. We now come to new clause 58. I call Matt Vickers.
Thank you. This clause empowers the Secretary of State to require revisions to any code of practice, policy guidance or strategic document issued by the College of Policing or the National Police Chiefs Council. It ensures that policing standards and practices remain aligned with the government's democratically accountable vision for public safety and law enforcement. The College of Policing and the NPCC play critical roles in setting the professional standards and operational frameworks that govern police conduct across England and Wales. However, these bodies are not directly accountable to the public. This clause ensures that when necessary, particularly in response to changing threats, public concerns or parliamentary direction, the Secretary of State has the power to intervene and ensure that these frameworks reflect the national interest and the expectations of the British people. Policing in the UK rightly enjoys operational independence, but operational independence is not the same as independence from oversight. When public confidence in policing is strained, whether due to failings in standards, inconsistency in approach, or a lack of responsiveness to major public concerns, the government must be able to act. This clause provides a clear, proportionate mechanism for ministerial oversight of the non-statutory frameworks that underpin much of modern policing policy. From rising levels of serious violence to emerging threats such as online abuse or disruptive protests, the nature of crime and disorder is changing rapidly. Government must be able to ensure that national policing guidance adapts accordingly. Whether it's guidance on stop and search, digital investigations, safeguarding or public order, it's vital that these documents are kept under review and reflect current priorities. This clause enables timely updates when needed, without undermining police independence in operational decisions. We've seen with the sentencing guidelines legislation the need for the government to intervene in order to prevent unhelpful practices that fly in the face of equality as well as public opinion. My colleague, the Shadow Home Secretary, has rightly highlighted that everyone must be treated equally before the law. Given the important role these bodies play, we'd welcome the added accountability that would come from allowing the Minister to intervene if necessary. Would the Minister not be grateful for the ability to take action if such a situation were to arise? This new clause does not erode public police independence. It reinforces public accountability. It ensures that when Parliament or the Secretary of State identifies a critical issue in how police standards are set or enforced, they have the tools to respond. In doing so, it helps maintain confidence in the police, strengthens the integrity of the policing profession, and ensures that national guidance reflects the values and priorities of the society it serves.
Amendment to the Police Act 1996.
The question is that new clause 58 be read a second time. Minister.
Thank you. And I am grateful for the Honourable Member for Stockton West for setting out his rationale for his amendment. There are a number of related issues which I want to refer to in my comments. So new clause 58 seeks to give power to the Home Secretary to amend or withdraw any code of practice or related guidance documents from the College of Policing and or the National Police Chiefs Council. So it is important that the Home Secretary, in her role being accountable to Parliament and the public for policing, works with policing bodies to ensure consistent standards and practice across England and Wales. The issuing of guidance is just, of course, one part of achieving that aim. Now, the Honourable Member referred to, in his comments, to the ability of ministers to take action. I think it's worth noting that there are existing provisions for the Home Secretary to approve the issuing of and any revisions to codes of practice published by the College of Policing. Such guidance is rightfully categorised as statutory and covers a wide range of issues from armed policing through to the requirements for ethical policing that are relevant to ensuring that the public is safe and that communities have confidence that officers are held to the highest standards. Now, whilst this amendment seeks to go further and provide the Home Secretary with powers to amend any guidance issued by the College of Policing and the NPCC, we should not forget, and in fact the Shadow Minister referred to this, that policing is operationally independent of government. This is a vital principle in our democratic society and fundamental to our model of policing by consent. Having said that, I should note that both the Home Secretary and I have very productive relationships with police leaders and work hand in hand to develop policy and guidance with the ultimate shared aim of keeping the public safe. I'd also remind members of the committee that the government will publish a white paper on police reform later this year. The Home Secretary has signalled her intention to work more closely with police leaders to drive improvements and ensure policing is set up to succeed. We will set out our plans for strengthening the way the policing system works to tackle a range of issues, from the future workforce to tackling fast-changing crime, and I would encourage all honourable members to engage with that work when consultation on the white paper opens. Now, as the honourable member set out, one of the factors that has inspired this new clause is recent issues that have arisen, including the update on the Police Race Action Plan. The plan is jointly developed by the NPCC and the College of Policing and commits to zero tolerance of racism in policing, something which I'm sure we can all agree on. And of course it is worth reflecting that this plan was originally published under the previous Conservative government. Now, I am supportive of the aims of the plan and completely reject the notion that the plan encourages preferential treatment for some groups over others. Of course, police officers should be conscious of the history of race relations in their local areas. This is, for example, in working perhaps with community leaders in a certain area and key stakeholders from different communities on issues such as, say, stop and search. However, having said that, the police are required to apply the law equally regardless of ethnicity. So in conclusion, I have to say to the Honourable Member that this new clause is, I think, misguided. But in any event, given the existing levers available to the Home Secretary in relation to statutory police guidance and the development of wider work on police reform, the new clause is unnecessary. And for these reasons, I would invite the Honourable Member to withdraw new clause 58.
Shadow Minister Mackler, please.
Thank you, move.
New clause 58 proposes on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
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 To the contrary, no.
No.
Division. Lock the doors.
Mr. Alex Barris-Curtis. Matt Bishop.
No.
David Burton-Sampson.
No.
Harriet Cross.
Aye.
Alex Davis-Jones.
No.
Dame Dan Johnson.
No.
Louise Jones.
No.
Keir Mather.
No.
Joe Platt.
No.
Jack Rankin.
Aye.
Dr. Lauren Sullivan. David Taylor.
No.
Luke Taylor.
Abstain.
Matt Vickers.
Aye.
The ayes were 3, the noes were 9, so the noes have it, the noes have it. Unlock. We now come to new clause 59, with which it will be convenient to also consider amendment 52 proposed to clause 135. I call Matt Vickers.
Thank you. New clause 59 sets out to abolish the non-crime hate incidents as a distinct form of police record. Police authorities will no longer be permitted to report, record or investigate such incidents unless specific exceptions apply. This marks a significant departure from previous practice where incidents not amounting to criminal conduct could still be logged if perceived as motivated by hostility related to protected characteristics. The clause establishes that the processing of relevant data by police authorities is unlawful under key UK data protection laws. Relevant data is defined as personal data related to a person's conduct that is unlikely to constitute criminal conduct, but has been perceived by someone else as motivated by hostility or prejudice. There is an exception to allow for relevant data to be processed where it is required for an ongoing criminal investigation or prosecution. Other forms of retention would have to meet stringent conditions. A police officer of the rank of inspector or above can authorise the retention of relevant data if they believe it is likely to materially assist in preventing or detecting future criminal conduct. By abolishing the category of non-crime hate incidents, the clause addresses widespread concerns about the chilling effect such records can have on free speech. Under the previous system, individuals could be recorded by the police simply for expressing controversial or unpopular opinions, even when no law was broken. This clause ensures that lawful speech is no longer subject to disproportionate scrutiny or police record. In addition, according to Policy Exchange, there are 13,200 non-crime hate incidents recorded per annum nationally. As such, they reasonably concluded that over 60,000 police hours each year are spent on NCHIs. Given the challenge currently facing the police, it's essential that they're able to focus on what matters most, tackling crime.
The retention by the police of non-crime perception records.
The question is the new clause 59 be read a second time. Minister.
Thank you. And new clause 59 seeks to abolish non-crime hate incidents and to make the processing of personal data in relation to those incidents unlawful. The new clause also seeks to introduce a new type of incident known as non-crime perception record to ensure data which may assist in the detection or prevention of criminal conduct can still be collected. It may be helpful for the committee to know that in 2023 the previous government introduced the statutory non-crime hate incidents code of practice on the recording and retention of personal data for police forces in England and Wales. And the College of Policing updated its operational guidance on hate crime for the police in 2023 to ensure it aligned with the code. And the College also publishes operational guidance known as authorised professional practice for numerous crime types and police business areas. So now I think honourable members should be in no doubt that this government's top priority for policing is delivering on our Safer Streets mission, including essential reforms to rebuild neighbourhood policing, restore public confidence and deliver on commitments to halve knife crime and violence against women and girls, as well as reducing antisocial behaviour. So against this backdrop, the Home Secretary has been clear that a consistent and common sense approach must be taken with non-crime hate incidents. Accordingly, she has already agreed that the National Police Chiefs Council, supported by the College of Policing, will conduct a review on their use and effectiveness. The review will cover when the police should record information that has not yet reached the criminal threshold, but which is still deemed necessary to monitor community tensions and keep the public safe. It will also consider the fundamental right of freedom of expression and recent court rulings in this area. The Government will work closely with the MPCC and the College as they develop their findings and any proposals. And I hope that the Honourable Member will agree it would be premature to make decisions on the future of non-crime hate incidents before the review concludes later this year, and I would therefore invite the Honourable Member to withdraw this new clause.
Shadow Minister Matt Vickers.
Take to move.
New clause 59 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division. Lock the doors.
Mr. Alex Barras-Curtis. Matt Bishop.
No.
David Burton-Sampson.
No.
Harriet Cross.
Aye.
Alex Davis-Jones.
No.
Dame Diana Johnson.
No.
Louise Jones.
No.
Keir Mabel.
No.
Jess Phillips.
No.
Joe Platt.
No.
Jack Rankin.
Aye.
Dr. Lauren Sullivan.
No.
David Taylor.
No.
Luke Taylor.
Abstain.
Matt Vickers.
Aye.
The ayes were 3, the noes were 10, so the noes have it, the noes have it. Unlock. We now come to new clause 60. I call Matt Vickers.
This clause seeks to amend sections 4A, 1A and B of the Public Order Act 1986 by removing the word insulting. The effect of this amendment would be to raise the threshold for the offence of intentional harassment, alarm or distress, ensuring that only behaviour that is threatening or abusive is captured under the offence. Freedom of expression is a cornerstone of British democracy. While it's vital to protect people from genuinely threatening or abusive behaviour, the inclusion of the term insulting in criminal legislation casts too wide a net. Insults, however unpleasant, are part of everyday life and public discourse. They should not, on their own, lead to criminal charges. This clause strikes a better balance between protecting individuals and upholding free speech. The word insulting is vague, subjective and open to interpretation. What one person finds insulting, another may see as fair comment or robust criticism. Laws should be clear and proportionate. Removing this term provides greater legal certainty and reduces the risk of overreach in public order policing, especially in the context of protests, political debate or challenging conversations in public spaces. The Government has already recognised these concerns. The word insulting was removed from Section 5 of the Public Order Act by the Crime and Courts Act 2013, following widespread concern about its chilling effect on speech. This amendment simply extends that same principle to Section 4A, which relates to intentional conduct. If insulting is not sufficient for non-intentional offences, it should not justify criminal liability when intent is alleged either. This clause helps to restore public confidence in the fairness and clarity of our public order laws. It ensures that not only serious conduct is subject to criminal sanction, while reaffirming the UK's commitment to open, democratic debate, even when it's uncomfortable or challenging. Removing the word insulting from Section 4A is a proportionate and necessary step to safeguard civil liberties without compromising public safety.
Threshold for intentional harassment, alarm or distress.
The question is that new clause 60 be read a second time. Minister.
Thank you. And as the Honourable Member has explained, new clause 60 seeks to remove the word insulting from section 4A of the Public Order Act 1986, which deals with intentional harassment, alarm or distress. This would raise the threshold for criminal liability by ensuring the law only captures behaviour and displays that are threatening or abusive and not insulting. Now, I fully understand the motivation behind this amendment, and I am sympathetic to the need to strengthen protections for free speech and to reduce the risk of criminalising conduct based on personal sensitivities. However, I do think there are legitimate concerns that removing insulting could narrow the tools available to respond to deliberate and targeted harassment. So given the potential implications the government believes this issue could raise, we believe it warrants further consideration, and I want to reflect on what the Shadow Minister has said, and I therefore would ask that the Shadow Minister at this time withdraws his clause.
Shadow Minister Matt Vickers.
Beg to move.
New clause 60 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
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 To the contrary, no.
No.
Division. Lock the doors.
Mr. Alex Barris Curtis?
No.
Matt Bishop?
No.
David Burton Sampson?
No.
Harriet Cross?
Aye.
Alex Davis Jones?
No.
Dame Dana Johnson?
No.
Louise Jones?
No.
Keir Mabber?
No.
Jess Phillips? Joe Platt?
No.
Jack Rankin? Dr. Lauren Sullivan? David Taylor? Luke Taylor? Matt Vickers?
Aye.
The ayes were 3, the noes were 11. So the noes have it, the noes have it. Unlock. We now come to new clause 95. I call Matt Vickers.
Littering from vehicles remains one of the most persistent and visible forms of environmental degradation on UK roads. Despite existing fines, enforcement has been inconsistent, and current penalties have proven proven insufficient to deter this irresponsible behaviour. By introducing the possibility of penalty points on a driving licence, this measure would add a meaningful consequence that better reflects the seriousness of the offence and its impact on the environment and local communities. The addition of driving licence points introduces a real deterrent by linking antisocial environmental behaviour directly to a person's ability to drive. Just as mobile phone use when driving or dangerous driving habits results in points, so too should reckless littering from vehicles. This aligns with the principle that the privilege of driving comes with broader responsibilities, including respect for public spaces and the environment. Roadside litter is not just unsightly, but it also poses real risk to wildlife, blocks drainage systems and requires expensive clean-up operations, costing local authorities tens of millions of pounds annually. A stronger deterrent, such as penalty points, would help reduce the burden on taxpayers and protect the UK's countryside, towns and roadsides. Similar approaches have been adopted internationally with success. For example, jurisdictions in Australia and parts of the United States have linked littering from vehicles to driving licence consequences, resulting in measurable behavioural changes. The UK should not lag behind in taking bold, effective steps to tackle this form of pollution and protect our environment and wildlife. A study by National Highways revealed that 65% of drivers who admit to littering have thrown food and drink packaging from their vehicles. Additionally, the road safety charity I Am Road Smart found that nearly 40% of motorcyclists had experienced car drivers or passengers throwing litter from windows whilst overtaking. The scale of the problem is huge. Roadside litter poses risks to wildlife, with discarded waste contributing to the deaths of millions of animals annually in the UK. Furthermore, the cost of clearing litter from roads is substantial. For instance, between April 2020 and March 2022, 45,000 bags of rubbish weighing 451 tonnes were collected from the M6 motorway alone. National Highways estimate that over 150,000 sacks of litter are collected by contractors every year, averaging 83 bags per mile of motorway annually. In short, introducing penalty points for littering from a vehicle would send a clear message that this type of behaviour is unacceptable and will carry real consequences. It would also reinforce the government's wider commitment to tackling environmental offences, empowering enforcement agencies and restoring pride in our public places.
Points on driving licence for littering out of a vehicle window.
The question is that new clause 95 be read a second time. Minister.
Thank you. New clause 95 seeks to add 3 penalty points to the driving licence of a person convicted of littering from a vehicle. And whilst I'm sure we all want to see robust consequences for those who throw litter onto our streets, we do need to carefully consider how workable this proposal actually is that's been put forward by the Honourable Member. Currently, the number of prosecutions for littering where litter was dropped from a vehicle is very low, due to the requirement for the individual to be identified, which can prove difficult. The The opportunity, therefore, for the courts to impose such a punishment would be very limited. The new clause also appears to assume that the person throwing the litter out of a vehicle is the driver, and this is not necessarily the case, and there will be instances where the offender does not have a driving licence to endorse in the first place. If the is the Honourable Member suggesting that in such cases the driver, including in some cases it could be a bus driver or a coach driver, should nevertheless be held liable? And I will, however, agree that this is a serious issue, and I'm going to ask my counterpart at DEFRA, who is responsible for policy on littering, to consider the benefits of designing a workable system to enable the endorsement of penalty points for littering offences committed from vehicles. I would add that local authorities can already issue civil penalties of up to £500 to the keeper of a vehicle from which litter has been thrown, and that amount will double if not paid within 28 days. This civil penalty was introduced considering the difficulty in identifying the individual who threw the litter. This can help, of course, where video evidence only shows the vehicle from which the litter has been thrown. And this civil penalty also provides a more immediate means of redress and prevents pressures on the court system. So I am grateful to the Shadow Minister for raising this issue, and I will, as I say, talk to my counterpart at DEFRA. However, for the reasons I've outlined, I would ask that he withdraws his new clause.
I thank the Minister for her comments, welcome the commitment to look at this as an issue, but would still wish to move to a division.
Okay. New clause 95 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division. Lock the doors.
Mr. Alex Barris-Curtis. Matt Bishop.
No.
David Burton-Sampson.
No.
Harriet Cross.
Aye.
Alex Davis-Jones.
No.
Dame Diana Johnson.
No.
Louise Jones.
No.
Keir Mather.
No.
Jess Phillips.
No.
Joe Platt.
No.
Jack Rankin. Dr. Lauren Sullivan.
No.
David Taylor.
No.
Luke Taylor.
Aye.
Matt Vickers.
Aye.
The ayes were 4, the noes were 11, so the noes have it, the noes have it. Unlocked. We now come to new clause 96, which has already been debated. Matt Vickers to move formally.
Beg to move.
Theft of tools from tradesmen.
The question is that new clause 96 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
Division 11.
Lock the doors.
Mr. Alex Barris-Curtis.
No.
Matt Bishop.
No.
David Burton-Sampson.
No.
Harriet Cross.
Aye.
Alex Davis-Jones.
No.
Dame Diana Johnson.
No.
Louise Jones. Keir Mather.
No.
Jess Phillips.
No.
Joe Platt.
No.
Jack Rankin.
Aye.
Dr. Lauren Sullivan.
No.
David Taylor. Luke Taylor.
Aye.
Matt Vickers.
Aye.
The ayes were 4, the noes were 11. The noes have it, the noes have it. Unlock. We now come to new clause 97. I call Matt Vickers.
New clause 97 ensures that taxpayers' money is not used to support organisations or groups that promote or condone criminal activity or seek to undermine the democratic fabric of the United Kingdom through violence or illegality. It's a fundamental principle that public funds, taxpayers' money, should serve the public good, not be channelled directly or indirectly towards those whose actions threaten public safety, the rule of law or constitutional order. By setting clear criteria for eligibility, this clause protects public trust in government spending and sends a strong signal that support for criminality or violent extremism will not be tolerated or subsidised by the state. It also provides a consistent basis for denying or withdrawing funds from groups whose conduct falls outside the bounds of lawful democratic engagement. Public funds must be allocated with care, transparency and accountability. It's vital that taxpayer money is not inadvertently used to support organisations that undermine the very laws, institutions and democratic values that uphold the UK's civil society. This clause ensures that public funds are directed to organisations that act in good faith and within the law, thereby maintaining public confidence in government funding mechanisms. The UK rightly protects the right to lawful protest and freedom of expression. However, there's a critical distinction between legitimate democratic dissent and organisations that support criminal conduct or use violence to pursue political or ideological goals. This clause draws that line clearly. Public money should never subsidise those who break the law or undermine democratic institutions through illegal means. The recent controversy surrounding the Irish rap group NECAM underscores the importance of this clause. The group has faced criticism for lyrics and public statements that appear to glorify violence and support prescribed terrorist organisations. For instance, during performances, a band member allegedly stated that the only good Tory is a dead Tory and suggested that people kill their local MP. He expressed support for groups banned in the UK. These actions have prompted investigations by British counter-terrorism police and raised concerns about the potential misuse of public funds in supporting such entities. By implementing this clause, we can prevent public money from being allocated to organisations that promote or condone criminal conduct, ensuring that funding supports lawful and constructive contributions to society.
Access to public funds for organisations supporting criminal conduct.
The question is that new clause 97 be read a second time. Minister, thank you.
New clause 97 seeks to block public funding of groups or organisations that promote criminal conduct or seek to subvert the democratic functions or constitutional integrity of the United Kingdom. Now, I understand from the Shadow Minister's remarks that this stems from comments made by a group who have previously received funding through the Music Export Growth Scheme, and the committee may find it helpful to be reminded that that decision was taken under the previous government and that it is this government that's had to deal with the consequences. Now, whilst I utterly condemn the remarks made by this group, I would stress to the committee that they are the subject of an ongoing police investigation, and it would therefore be inappropriate to comment any further. However, I do want to make it clear that the government does not believe individuals expressing the views that we've heard should be receiving taxpayer funding. And I know that my right honourable friend, the Prime Minister, has asked the Secretary of State for Culture, Media and Sport to urgently review the Music Export Growth Scheme in light of the comments that have emerged. It would be right to wait for that review to conclude before considering what further action may need to be taken. And therefore I ask that the Honourable Member withdraws new clause 97.
Yes. Shall I move to that bit, please?
Thank you, move.
New clause 97 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
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 To the contrary, no.
No.
Division. Lock the doors.
Mr Alex Barras-Curtis?
No.
Matt Bishop?
No.
David Burton-Sampson?
No.
Harriet Cross?
Aye.
Alex Davis-Jones?
No.
Dame Diana Johnson?
No.
Louise Jones? Keir Mabber?
No.
Jess Phillips?
No.
Joe Platt?
No.
Jack Rankin? Joe Robertson? Dr Lauren Sullivan?
No.
David Taylor?
No.
Luke Taylor?
Abstain.
Matt Vickers?
Aye.
The ayes were 4, the noes were 10, so the noes have it, the noes have it. We now come to new clause 98, which has already been debated. Matt Vickers to move formally.
Thank to move.
Enforcement plan for sale of stolen equipment at car boot sales.
The question is that new clause 98 be read a second time. As many as are of that opinion say aye.
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 Of the contrary, no.
No.
Division. Lock the doors.
Mr Alex Barras-Curtis? Matt Bishop?
No.
David Burton-Sampson?
No.
Harriet Cross?
Aye.
Alex Davis-Jones?
No.
Dame Diana Johnson?
No.
Louise Jones. Keir Mather.
No.
Jess Phillips.
No.
Joe Platt.
No.
Jack Rankin.
Aye.
Joe Robertson.
Aye.
Dr. Lawrence Sullivan.
No.
David Taylor.
No.
Luke Taylor. Matt Vickers.
Aye.
The ayes were 4, the noes were 10, so the noes have it, the noes have it. Unlocked. We now come to new clause 99. I call Matt Vickers.
This new clause addresses a crucial gap in the current police inspection framework. Over the years, tragic incidents have demonstrated the potential consequences of failures within firearms licensing. Public confidence in the licensing process hinges on the assurance that robust, consistent and professional standards are being applied across all police forces. While some forces operate highly effective systems, others have been found lacking, sometimes with devastating outcomes. Yet at present, there is no statutory requirement for HM Inspectorate Constabulary and Fire and Rescue Services to review firearms licensing performance as part of their routine PEEL inspections. This clause would put that right. It ensures that the inspection of firearms licensing departments become a core part of how we assess the overall efficiency and effectiveness of police forces. By embedding this into the statutory inspection framework, we send a clear signal that public safety and accountability in firearms licensing is not optional, but essential. I'd like to pay tribute to the Honourable Member for North Cotswolds for his dedicated service as Chair of the All-Party Parliamentary Group for Shooting and Conservation. Throughout his tenure, Sir Geoffrey has been a steadfast advocate for responsible shooting practices and the preservation of our countryside. The Honourable Member's efforts have significantly contributed to the ongoing discourse on firearms licensing and the importance of effective oversight in this area. His work underscores the need for continuous evaluation and improvement of our systems to ensure public safety and trust. Importantly, this clause does not impose undue burden on our forces. It simply makes explicit what many would already expect to be standard practice, that the licensing of deadly weapons should be subject to the same scrutiny and performance benchmarks as other areas of policing. It's a measured, reasonable and necessary step towards a safer, more consistent and more transparent firearms licensing regime across England and Wales.
Inspection of police force firearms licensing departments.
The question is that new clause 99 be read a second time. Minister.
Thank you. And I thank the Shadow Minister for explaining new clause 99 and also note the work of the Honourable Member for, I think it's the right Honourable Member actually, for North Cotswolds, and in fact I'm due to meet him soon on this very subject of firearms. So this clause would require every police efficiency, effectiveness and legitimacy inspection, which are also known as PEEL inspections, to include an inspection of the efficiency and effectiveness of a police force's firearms licensing department. And I hope I can try and persuade the Honourable Member that this change is unnecessary and indeed damaging, as it would curtail the independence of His Majesty's Inspectorate of Constabulary and Fire and Rescue Services, known as HMIC FRS, and its freedom to shine a light on the most pertinent issues facing policing. It's vitally important that HMIC FRS is independent from policing and from the government. As part of this, it must have the freedom to set its own inspection programmes and frameworks when deciding how to assess the efficiency and effectiveness of police forces in England and Wales. This allows it to inspect police forces on the most pertinent and high-profile issues facing policing, and to assess the basics of forces' operational and organisational activity. Indeed, there is no other area of policing where the law sets out what the inspectorate must include in its regular inspections, and the change proposed by this new clause would set a most unhelpful precedent. HMIC FRS conducts detailed sector consultations ahead of each PEEL cycle to determine what will be covered in its assessment framework and how forces will be graded. It regularly updates its framework as necessary to include or remove areas for assessment where it identifies priority issues. HMIC FRS also consults publicly on its inspection programme and frameworks before they are laid in Parliament. It consulted publicly on their latest programme covering 25 to 29 late last year. The final programme was published in March 25, following the approval of the Home Secretary. The Home Secretary also already has appropriate powers to commission the Inspectorate to conduct additional inspections into high-profile and concerning issues should the need arise, and we saw that with the summer disorder last year. If there are concerns about a force's performance in respect of firearms licensing, the local policing body may also commission the Inspectorate to assess its efficiency and effectiveness. In line with our manifesto commitment, we will further empower HMIC FRS to intervene in failing forces to ensure that the most high-risk recommendations it makes are properly acted upon by police forces. As part of its recently approved programme, HMIC FRS plans to commence a thematic inspection into firearms licensing later this year. It will use this inspection to highlight good practice and make recommendations for improvement to all police forces. The Government will carefully consider the outcome of this inspection and any recommendations made to us following it. Now, firearms licensing by police forces is, of course, fundamental to keeping the public safe. We keep firearms licensing under review, and in February we published the Government response to the 2023 firearms licensing consultation, containing a number of important commitments focused on continuing to improve firearms licensing controls. We will shortly be issuing refreshed statutory guidance to Chief Officers of Police on firearms licensing, which will contain stronger guidance for police licensing departments around domestic abuse, evidence of violence and the requirements for referees for firearms applications. There is also now a national programme of training in place on firearms licensing for forces across England and Wales run by the College of Policing. This will drive up standards and deliver a more consistent approach and good practice across police forces. This training is considered to be mandatory for forces, and we are amending the statutory guidance to make that clear. In addition, the performance of firearms licensing departments in forces is being monitored by the National Police Chiefs Council Lead for Firearms Licensing, Deputy Chief Constable David Gardner. He has developed a table setting out performance data for firearms licensing departments in police forces, which was published in April this year and will be updated every quarter. It includes the percentage of applications received and decided in the 4 months by forces. This table provides greater transparency on performance, including in relation to the time taken by licensing teams when dealing with firearms licensing applications. So for all these reasons that I've set out, I think that this new clause is unnecessary, and I urge the Honourable Member to withdraw it.
The question is that new clause 99 be read a second time.
Beg to move.
New clause 99 proposed as on the amendment paper. The question is the clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division. Lock the doors.
Mr. Alex Barris Curtis.
No.
Matt Bishop.
No.
David Burton Sampson.
No.
Harriet Cross.
Aye.
Alex Davis Jones.
No.
Jane Dana Johnson.
No.
Louise Jones.
No.
Keir Mather.
No.
Jess Phillips.
No.
Joe Platt.
No.
Jack Rankin.
Aye.
Joe Robertson.
Aye.
Dr. Lauren Sullivan.
No.
David Taylor.
No.
Luke Taylor.
Aye.
Matt Vickers.
Aye.
The ayes were 5, the noes were 11, the noes have it. Unlock. Government News Schedule 1 has already been debated. Minister to move formally.
Civil penalties for service providers and content managers.
The question is that News Schedule 1 be read a second time. As many as are of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 131 stand apart, with which it will be convenient to also consider clauses 132 to 137 stand apart, Government Amendment 79 to Clause 132, Government Amendments 18, 20, 19, 21, 80, 22, 82 to Clause 134. Government Amendment 83 and 23 and Amendment 52 to Clause 135. Minister.
Dr. Khan, I'd like to move those formally.
The question is that Clause 131 stand part of the bill. As many as are of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. Government Amendment 79 to Clause 132 has already been debated. I call the Minister to move that amendment formally. The question is that Government Amendment 79 to Clause 132 be made. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Clause 132 as amended has already been debated. The question is that Clause 132 as amended stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Clause 133 has already been debated. The question is that Clause 133 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. Government Amendments 81, 18, 20, 19, 21, 80, 22 and 82 to Clause 134 have already been debated. With the leave of the committee, I will put a single question on those amendments. The question is that Government Amendments 81, 18, 20, 19, 21, 80, 22 and 82 be made to Clause 134. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. Clause 134 as amended has already been debated. The question is that Clause 134 as amended stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. Government Amendments 83 and 23 to Clause 135 have already been debated. With the leave of the committee, I will put a single question on those amendments. The question is that the Government Amendments 83 and 23 be made to Clause 135. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. Clause 135 as amended has already been debated. The question is that Clause 135 as amended stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. Clauses 136 and 137 have already been debated. With the leave of the committee, I will put a single question on those clauses. The question is that clauses 136 and 137 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The final question I must put is that I do report the bill as amended to the House.
Could I do a point of order at this point?
Yes, Minister.
Thank you very much. And just before we conclude this Bill Committee, it is customary at this stage of our proceedings just to say a few words to mark the end of our deliberations in committee. It certainly feels a very long time ago since we started this committee process, and I was just reflecting on the tumultuous events which have happened while this committee has been sitting. I think we've had the death of the Pope and the election of a new Pope. We've had the saving of the British steel industry, and we've had some rather interesting local elections as well during this time. So against this backdrop, I think whilst we've had some disagreements, particularly over some of the new clauses, I do welcome the fact that the measures in this bill command a substantial degree of cross-party support. And I've also certainly learnt a few new things as well. I had no idea what potting was until my honourable friend raised that in the committee. So I am very pleased that the provisions in this bill and the near 100 new clauses have had the benefit of rigorous scrutiny by honourable members on both sides of the committee over the 8 days that we've been sitting. And I want to thank in particular you as the chair and your co-chairs, Sir Roger Gale, Miss Lewell, Mr Pritchard, for keeping us all in very good order. My honourable friends, the members for Birmingham, Yardley and Pontypridd, for womanfully, I think, sharing the considerable workload in committee with me. For the Government Whip, my honourable friend, the member for Selby, for keeping us all in good order. And the opposition front bench, the Honourable Member for Stockton West, who I think must be setting some new parliamentary record for the number of back-to-back bills that he's been leading on for the opposition, and the Honourable Member for Gordon and Buchan, who reminded us that the proceedings on a public bill committee are a marathon and not a sprint. And I certainly think that one of the contributions that she made was certainly a marathon in terms of the speaking notes that she had provided for her. I also, of course, want to thank the clerks, the Hansard writers and the doorkeepers. And also, I just want to pay tribute to all of the honourable members who've served so diligently on this committee from both sides and made such thoughtful and valuable contributions to this committee part of the bill. I also need to say, of course, the bill teams and the other officials and lawyers from the Home Office, the Ministry of Justice, the Department for Transport, the Department for the Environment, Food and Rural Affairs, and the Department for Science, Innovation and Technology, who've all provided such excellent support to the committee. The bill, I believe, is much enhanced as a result of our deliberations, and with the new measures we've added and with all the more will go to helping us with the delivery of the Safer Streets mission. I've just realised, of course, I haven't paid tribute to the Liberal Democrat members of this committee, and I do want to do so. I don't want them to feel missed out, so I also want to thank them for their contributions as well. And I look forward that we will have further debate at report stage, which will come shortly, I'm sure. But on that basis, thank you, Dr. Owen Carn.
The question is that I do report the bill as amended to the House. As many as are of that opinion say aye. Aye. To the contrary, no. I think the ayes have it, the ayes have it. The committee has concluded its work. Order, order.